Good morning.
Good
Just-
morning.
Just letting you know that we do know you're in the waiting room. The other party is not checked in yet, the other attorney. So,
Okay.
so just hang in there with us, okay?
Sure, no problem. I'm in no hurry today. Thank you very much.
Thank you. I'm going to put
Yeah.
you back in the waiting room for a few.
Sure, thank you very much.
We've got one attorney and two defendants. None of them are on the same case. No, let me make you co-host. Sorry. There you go.
Good morning. Appearances on Automobile Club versus Graham.
Yes, good morning. Brittany Rocha, appear on behalf of the plaintiff.
Good morning, Your Honor. Pradeep Svantanathan on behalf of the defendant.
Good morning. So what do you guys need from the court for pretrial? You need any discovery time? You ready for motions? Where are we at?
I believe discovery, a period of discovery would be helpful in the matter.
All right. 60 days give you enough time? We'll schedule another pretrial.
That works for plaintiff, yes.
Yes.
All right. For $3 grand, I'm assuming we're not going to do depths.
Plaintiff,
hope-
yeah.
Written discovery only then?
Yes.
All right. Anything else we can do today?
Not from defendant's end, Your Honor.
Not from the plaintiff's end, Your
All
Honor.
right. We'll send out another notice for pretrial that'll be at least 60 days down the road.
Thank you.
Thank
Have a
you.
great day, people.
You too.
Thank you.
I'm going to bring in the LG Stylo 5,
Yep.
find out who it is. In the waiting room, that top one, Marcia Cracer, is an attorney on the very first case,
Right.
and the other two are defendants. Good morning, LG Stylo 5. Can you tell me your name, please?
Anastasia Turner.
Beaumont
Okay.
Health case, Paula.
Anastasia Turner. Good morning.
Okay. There we go. Now I got you renamed. Anastasia, you're the only one that's checked in on that case so far. So I'm just going to put you back into the waiting room for a few minutes till we get the other side, okay?
Okay.
Thank you.
Mhm.
Good morning, Mr. Applebaum. Can you tell me what case you're on, please?
Good morning. Briggs Realty versus Rely Investments.
Okay, so you're appearing for Mr. Witham?
Yeah, same firm. He couldn't make it.
Okay, can you hang on just a moment, please?
Absolutely.
Thank you.
Thank you.
You were on the phone, so I thought I was.
Hello?
Hello, we have Mr. Applebaum on and for Mr. Witham and judges on as well.
Hi, good morning.
Good morning, counselors. Appearances on Briggs Realty versus Rely Investments.
David Applebaum for the plaintiff.
Good morning, Your Honor. Marcia Krejci on behalf of the defendants, Raleigh Investment and Renee Lamone.
On behalf of Briggs,
Yes.
your name, please.
Oh, David Applebaum.
Thank you. This is an adjourned pretrial. We had this matter up December 15th. We adjourned it for written discovery. So where are we at?
I believe, Your Honor, we have resolved this case. We just need to get the paperwork in. My client has agreed to pay $6,500 within 30 days of your signing the dismissal. And I believe this will be a dismissal with prejudice that I've discussed with Mr. Witham.
Okay. So how much time you need to get some paperwork in? We'll set it for an in-house review.
Mr. Applebaum, does a month sound pretty good?
Yeah, 30 days should be sufficient.
All right. Anything else we can do today?
Have a good day, Your Honor.
All righty.
Nothing from
You too.
Thank you, guys.
Bye-bye.
Bye.
Bye-bye.
Okay, that last attorney, Dylan Stack, I don't know if he's with the plaintiff or the defendant, but he is on United Lab versus Nationwide at 8:45.
All right. Let's talk to, let's bring Parton in for a minute. Miss Parton, are you connected?
Yes, I'm here.
All right, Miss Parton, I understand you spoke to somebody from Crown Asset and they agreed to adjourn this matter today?
Yes.
All right, we'll send out a new notice.
Okay.
You've got another one scheduled at 9 o'clock, correct?
Yes.
All
And I
right,
also asked for an adjournment on that too, but I couldn't get Miss Elizabeth Smith to return a call and her email was bad.
all right. As soon as I catch up here, I'll try to make a phone call to that office, see if we can get them online.
Okay.
All right, we'll put you back in the waiting room for now.
Thank you.
Ursula Porter is one of the, or is the plaintiff. It's at 9:30. Porter
Yeah,
versus
I knew she'd be
Barrington.
in early.
Okay. I've got them all accounted for, but there's only one on each side. Let's see who that is. Good morning. This is Ms. Zadrowski.
Yes,
Okay. What case are you on, please?
I'm here on Ford Motor Credit Company versus Sharina Muriel.
Okay, so you're in for Michael Zuba?
Yes.
Thank you. I'm gonna just put that on there.
Okay.
So when we pull you in, we'll know who you're for.
Okay.
Okay, I'm gonna put you back into the waiting room till we get both parties, okay?
Okay, thank you.
Thank you. Judge, I have both parties.
Good morning. Appearances for United Lab versus Nationwide Mutual.
Morning, Your Honor. John Betts on behalf of the plaintiff.
Good morning, Your Honor. Dylan Steck appearing on behalf of defendant Nationwide.
Good morning, gentlemen. So let's see. This is an adjourned pretrial from mid-December, adjourned for written discovery. Where are we at?
Well, the last time we spoke, defense counsel said he wanted to depose Argy Watson, the injured party here, in Argy Watson's separate suit. And I don't know if that has occurred. There's been really no communication from the other side.
Your Honor, Ms. Watson's dep is scheduled for next Wednesday, March 23rd. That's the last box I need to check here. Once I get that done, my client will give me authority. I can settle this one out with Mr. Betts.
All right. So you want me to just put it out on my next pretrial docket?
That's fine.
That would work for us, Your Honor.
So as long as you get at least 3 weeks, that's enough time?
That should be sufficient, Your Honor.
Mr. Betts, agreed? All right. Have a good day, gentlemen.
Thank you, Your Honor.
I have both parties on Ford Motor versus Sharina. But she's checked in twice, so I don't know if we're going to have problem with.
Yeah, let's find out.
All right, I'll bring her in. She connected.
All right. Good morning, counsel. Your appearance on Ford Motor Company versus Morel.
Good morning, Robin Stradowski on behalf of Ford Motor Credit Company.
All right. Ms. Morel, can you hear me?
She's muted.
Ms. Morel, you are muted.
You have to push. There you go.
There you go. Good morning.
Good morning.
All right, Ms. Muriel, this is a matter set for a pretrial today. A pretrial gives me an opportunity to get some information from both you and the attorney to find out what's going on with the file, hopefully put it on our calendar and move it towards a resolution. Counsel, where are we at on your end? You need discovery? You ready for motion, trial? Where are we at?
Yes, if you could give us some time for discovery and a chance to file a motion for summary disposition if we're not able to resolve this.
All right, 30 days, 60 days, what are you looking for?
60 days, please.
All right, Ms. Morel, give me just a minute. I'm gonna explain this.
Okay.
And for this kind of money, I'm assuming we're talking about written discovery only, counsel?
Yes.
All right, so my note's gonna be 60 days written discovery, plaintiff to file a motion and notice it up.
That's correct. Thank you.
All right. All right, Ms. Morel, discovery is a request for information. In the legal business, we use a lot of words that the regular world doesn't use. So we have special words for everything. So counsel, correct me if I misspeak, but counsel's probably going to send you a list of questions, ask you to answer those questions, might send you a request for a document or two. You can do the same thing. Discovery is supposed to be a two-way street. So if there's any information or missing documents that you need to prepare your defense against the claim from Ford Motor, you can ask counsel for those. You understand that?
Yes,
Okay. Now she says she's going to file a motion. I'm assuming motion for summary disposition, counsel.
Yes.
Okay. That's another one of those words, Ms. Morel, that the legal profession uses just when we mean something else. Motion means request. So counsel, on behalf of Ford Motor Company, plans on filing a motion or a request to the court saying there are no important facts that are in dispute. Based on the facts that are not in dispute and the law that applies to those facts, Ford Motor Company is entitled to a judgment. That's going to be a written document they're going to file with the court. They're going to send a copy to you. You can respond to that in writing. I would encourage you to do so. But even if you don't do that, you're going to get a chance to respond to it orally because there'll be a motion hearing date. At that hearing, I'm going to listen to anything that counsel wants to add to what she put in writing. I'm going to listen to what you have to say, and then I'm going to make a decision on whether or not I agree with their position. If I agree with Ford Motor Company, then I'm going to issue a judgment against you on behalf of Ford Motor Company at that point in time. If I deny their motion, if I decide, for example, that there are some facts that are in dispute that are important to this case, then I'm going to deny the motion. That means we're going to go forward and probably set the case for trial at that point. Do you understand all that?
yes.
Okay. Do you have any questions about the process, ma'am?
No, not so far. I'll just wait for paperwork, I guess.
Okay. And that's going to be coming. Counsel, anything else?
No, if we could, so I'd like to try to work this out with Ms. Murrell, discuss this. I'm not sure if we have a good phone number for you. Is there a good number that we could reach you at while we're here together?
You can do my cell, which is 313-590-1440.
Okay, thank you.
All right. And I've also put that in the court file. All right. So counsel, you'll reach out to her to talk about possible settlement?
Yes.
Okay. Anything else, ladies? Any questions, Ms. Morel?
No.
All right. Good luck to you.
All right,
Counsel,
thank
stay
you, Your
safe.
Honor.
You're welcome.
Have a good day.
You as well.
I do have an attorney in there, Judge. I got to find out who that is. Let me
Okay.
take care of her. There we go. Good morning, Mr. Groen. Can you tell me which case or cases that you're appearing on, please?
Sure. I have one at 8:45 for LVNV funding Cassandra Akins.
Okay, you're appearing for Nate Preston.
That's correct.
Thank
Actually,
you.
I think Preston Nate is on all these. I'm also on two of them at 9 o'clock. There's an
Yeah.
LVNV funding Tiffany Davis.
And you got one at 9:15 as well.
Yeah.
Well, let's take the first one.
Sure.
That would be LVNV versus Cassandra Akins. Hang on just a moment.
No problem.
Good morning, Miss Akins.
Good morning.
We're just waiting for the judge. It'll just be one moment. We do have the attorney in as well. So I'm
Yes.
gonna.
All right, thank you.
You're welcome.
Counsel, your appearance on LVNV funding versus Akins, please.
Good morning, Your Honor. Brian Gruen, Groen, P number is 56673 on behalf of plaintiff LVNV funding.
Thank you. And Miss Akins, can you hear me?
Yes, sir.
Good morning.
Good morning.
All right, this is a date and time set for a pretrial. Miss Akins, a pretrial gives me an opportunity to get some questions answered and get some information about the file from you and counsel. Hopefully, we put this on the calendar and move it towards a resolution. Do you understand that?
Yes, sir.
Counsel, where are we at from the plaintiff standpoint?
Your Honor, we actually didn't even receive a copy of the answer, so I'm not really sure where to go. This is just a credit card debt, credit one bank, credit card. Charge off amount is the amount cited in the complaint of $841.54.
All right. You know what, counsel? If you send your email by chat, we can email you. It's like a one paragraph answer from Miss Akins. We can email that to you right now. We'll put you.
If you want to just paraphrase what she said, Your Honor, that'd be great. Rather
Okay.
than if it's one paragraph, I figure I can take quick notes.
Sure, Miss Akins, I'm gonna try to do that. You correct me if I say anything that's not true. Okay.
Okay.
All right. So basically, Miss Akins admits that she had a credit card at some point in time, with a limit of $400. She did fall short with her payments. Card was canceled, and if paraphrasing, it looks like she agrees she owes some money. She's just a little bit blown away by the fact that now she owes more than double her original credit limit. Miss Akins, had a pretty good summary?
Yes, it is.
Okay, so I'm going to
Thank you, Your Honor.
guess, Miss Akins, I'm going to guess you're probably willing to work something out depending on the details.
That is correct. And I did put that in the letter, what I would be able to.
Counsel, why don't we put you two in a breakout room and see if you can maybe settle this case today? If not, we'll talk about a calendar.
Perfect. That sounds great, Your Honor.
Miss Akins, understood?
Yes, sir.
All right, we're going to put you in a private room with counsel so you can have some conversation.
Thank you.
And good luck to you.
Thank you, sir.
You're welcome.
I'm going to bring in the iPhone to find out who that is.
I clicked them.
Oh, okay. Good morning, whoever's on the iPhone. Can you tell me what case you're here on, please? And your name?
Yeah. Yes, and I apologize. I thought I changed my iPhone to say my name. This is Hal Burke. I'm an attorney in Toledo, and it should be Beaumont Health versus Antasia Turner.
Yep, bringing her in right now.
Thank you. Does it not say my name on there?
It does. It does now. Paula, just put your name on it.
Thanks, Paula. I apologize.
That's okay.
Counsel, would you put your appearance on the record for Beaumont?
Sure, Your Honor. This is Hal Burke. I'm an attorney for Beaumont for the plaintiff.
Thank you. And Ms. Turner, can you hear us?
Yes.
All right. Good morning, ma'am.
Good morning.
So today's a date and time set for a pretrial. A pretrial is an opportunity for me to get some information from the parties, so I know a little bit more about what's going on with the case and hopefully put it on a calendar and move it towards a resolution.
Okay.
It looks like from your answer, Ms. Turner, and counsel, did you get a copy of that answer?
I did.
Okay.
Yes, I did.
All right. It looks like from your answer that you agree that the services were provided. You just think your insurance company should have taken care of it.
Right, and they did.
Okay. You got some documentation of that, ma'am?
Yes, I do.
Awesome. Have you shared that with plaintiff's counsel yet?
No.
All right, counsel, I'm going to suggest maybe we put you in a breakout room and see if maybe you can do a little exchange of information.
That would be great. And I always like to go in there unless she would just take my email, because if she emails me what she has, if she's willing to, I could maybe clear this up. If not today, sometime tomorrow.
Ms. Turner, can you email that to him?
Yes. I don't have a pen and paper just yet.
So why don't we put you in a breakout room and maybe you can take care of all that right now?
Okay, that's fine.
Thank you.
All right. Thank you. Go ahead and Ms. Turner, go ahead and find an ink pen or something while we put you in a breakout.
Okay.
Paul, while you're doing that, I'm going to talk to Ms. Porter.
Looks like she walked away for a little bit.
Yeah, and she's not connected. I'm gonna call her. Well, that's weird. Got a few ready, James. Thank you.
It looks like she may have put us on hold to answer it.
Well, the funny thing is I dialed her number, but it didn't even ring. You don't have anything else ready, do you?
No, there's an attorney that just checked in, but I don't know who he's here on. I don't see him on the docket, so.
Go ahead. Figure
Okay.
that out. I'll mute on my end.
All right. Good morning, Mr. Gerda.
Good morning.
Can you tell me what case you're here on, please?
It's Dawn Giller versus Gurjeet Singh and Pujab
So you're here
Investments.
for Aaron Cox's office?
That's correct.
Okay. I'm going to put you back into the waiting room for just a few minutes, and we'll pull you out in just a second, okay?
Very good. Thank you.
Judge, we do have Dawn Giller, and that attorney was on behalf of Aaron Cox. So as soon as we're finished with Mr. Burke. You're on mute.
It looks like we're waiting for Miss Burke or Miss Turner to come out of the breakout from talking to Mr. Burke.
Okay.
Your Honor, I can tell you what we did, and I
Please.
did. I tried to explain to her how to not leave the meeting, but just leave the breakout room. Either way, we did. Thank you. We did. She did get my email address. She kind of held up her
I'm
piece
here.
of paper. Oh, she said she's here.
She's back. Yep.
Okay. My, you can make it my request, whatever permission you would like. And that is, she's going to email me, I believe today, that proof that she believes this has been paid. And my request is if you'd give me a week or less, whatever you'd like, to verify the payment and maybe to continue moving on the case. If it's not the right information,
Sure.
maybe adjourning this and setting it for another final pretrial.
Yeah,
whatever
what I'll do is I'll have the clerk set it for my next pretrial docket. If you two resolve it before then, that's great. If not, we'll have a pretrial next time.
I appreciate it. Thank you.
Ms. Turner, that makes sense? Any questions?
Yes, no,
Yes, it makes sense. No questions.
no. Right.
Okay. All right. My question was a bad one, so that's why your answer was confusing. All right. Good luck to you, Ms. Turner. Have a nice day.
Thank you. Have a great day.
Bye-bye. Bye.
We also have Mr.
Yep.
Groen and Akins back.
Yep. Ms. Akins, you can hear me?
Yes, sir.
All right. Counsel, where are we at on this one?
Your Honor, I think we've come to an agreement. We just need some time to get the consent judgment over to Ms. Atkins, and hopefully that will take care of this matter. So if we can just adjourn this to your next pretrial date, I think hopefully.
How about
that
if we
should
just
be-
do this? I'll set it for an in-house review 30 days out with the idea we're going to have a settlement document before then. And if not, we'll set something else on the calendar.
We'll reset the pretrial at a later date then, if we don't
Yep.
get it. Perfect.
Ms. Akins, that work?
That works for me.
All right. Good luck to you.
Thank you. You guys have a
You're
wonderful
welcome.
day. God bless
You
you.
as well.
Thank you, Ms.
Yes.
Atkins.
Bye-bye.
Okay, Judge, we do have two other people in there for Mr. Groen. We have Don Snyder, who's scheduled at 9 o'clock.
Let's take care of the 9 o'clock. Well, let's
He's
see.
got two of them scheduled at 9.
Who's he got at 9?
He's got Citibank versus Snyder and LVNV versus Davis.
Is
All right,
Ms. Davis on the line too?
She was.
Okay, because that might be quicker, because that one we've already come to an agreement. So if we,
It looks like she bugged out. Let me
did she? Okay, well, we can take care of her again in a little bit then.
Let's bring Miss Snyder in then.
Okay.
While she's trying to connect, I'll bring Miss Davis in.
She just came back in.
All right, Miss Davis, can you hear me?
Yes, I can.
All right. Good morning.
Good morning. How are you?
Excellent. Mr. Groen, your appearance for LV Envy.
Good morning once again, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff LVNV Funding.
And you were saying before we had Miss Davis in that you think this case has been resolved?
It has been resolved. Ms. Davis called her office yesterday and confirmed she can verify this if I'm misstating, but she verified that she did receive our consent judgment. And I believe she's going to be signing that and mailing it back to us. So if the court is willing to set another control date out, and hopefully we should be getting that consent judgment to you once we receive it back from Ms. Davis.
Great. I'll do it the same way as the last file. Ms. Davis, I'm going to set an in-house review for 30 days. Gives you plenty of time to get the documents exchanged between you and counsel and get it to the court. If something happens, we don't have that document within 30 days, then we're just going to schedule another pretrial and send out a computer notice.
Okay. No, I got
Make
it.
sense?
I can do that. Yes.
All right. Any questions, ma'am?
No, I do just want to ask if they did get my updated address. I just want to make sure because it's going to an old address.
Are you talking about a snail mail address or an email address?
My snail mail.
Okay. Counsel, can you confirm that?
Let me pull up her file. I know another attorney took her call, so I just want to make sure he noted the address correctly. So let me put this in a second.
Ms. Snyder will be with you in just a minute.
Okay, thank you.
You're welcome.
Tiffany 9835 Julie Drive.
Correct.
Is that the one in Ypsilanti? Okay.
Yes,
Yep.
that's my new one. Okay, thank you.
Yep, well, you should be all set then.
Okay, thank you so much.
Thank you.
Have a good day, ma'am.
Thank you too. Take care. Bye.
All right. Counsel, your appearance on behalf of Citibank versus Snyder.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff Citibank.
All right. Ms. Snyder, today's date and time set for pretrial on this file. A pretrial gives me a chance to get some information from the parties about this particular file. Hopefully with the thought that we put it on the calendar and move it towards a resolution. Do you understand that?
Yes, sir.
All right. Counsel, where are we at?
Your Honor, actually, we're in good shape with this one. Ms. Snyder has been making payments. The only thing is we sent her a proposed consent judgment a little over a month ago, and we have not received it back. So I just need to confirm, did you ever receive the consent judgment from our office, Ms. Snyder?
I did, sir. The reason I didn't send it back was because I talked with the lady from your office many months ago, like last year sometime, maybe around September. And I told her I wanted to make arrangements to start paying on it. And she said, okay. She said that if I paid $75, that I wouldn't have a judgment. And I told her that, I pay almost $600 a month in student loans. And right now, the only reason I've been able to pay $75 every 2 weeks to you is because my student loans are in deferment. And I asked for her to
turn it off,
to lower it to 50. And she said she couldn't do that. So since you guys went ahead and did a judgment anyway, I was going to ask the court if I could lower that to $50 every 2 weeks, because once the student loan deferment ends in September when it's due, I'm going to be back up against the wall I know it seems like it's only $25 every 2 weeks, but that's how I pay my student loan.
If I tell you what, I can revise the consent judgment and do the $50 biweekly payments. And how about you? We can't change it that quickly. How about as of maybe like a month from now, it can switch to the $50 payments? Would that work if I put in that?
I can continue to pay the 75 until our student loans go back in deferment. I
Well,
mean,
tell you what,
till
yeah.
the national deferment is over.
Tell you what, I'll just put it the $50 amount bi-weekly to begin in the month. If you want to keep making the $75, it's going to keep, your judgment's going to go lower by that much more each month that you can pay more.
Right.
But at any point that you need to reduce it back to that 50, then you should be good to go from that point forward.
Okay. I'm agreeable to that.
Are you still at the 9463 Barry Drive address then in Romulus?
Yes, sir.
Okay, so what I'll do is
Yes, sir.
I'll revise the consent judgment to do those new terms that we just discussed, and I will get that out to you hopefully by the end of the week. Okay?
Okay.
All right, so what we'll do is we'll set it for an in-house review 30 days out, gives you a chance to exchange the information and get it to the court. If we don't have that final document within 30 days, Ms. Snyder, the computer will kick out another notice for a pretrial, just like the one that was scheduled for today.
Yes, sir.
All right? Any
Yes, sir.
questions?
No, sir.
Good luck to you. Counsel, thank you.
Bye-bye.
I have one more, Your Honor.
Oh, I thought that was for me. Okay, have a
No,
good one.
you're all
Bye-bye.
set. Thank you, Ms. Snyder.
Ms. Dumas has not checked in yet. So I'm going to put you back in the waiting room for a few until she does, okay?
I'll say it's not even time yet, so that's perfect. Thank you so much.
Thank you, sir.
Paula, give me a second. I want to talk to Ms. Porter real quick, and then we'll bring in the Giller party.
Thank you.
Ms. Porter, I got you muted. Can you unmute?
Yes, sir.
There you are. Good morning. How are you today?
Good morning, Judge Oakley.
All right, so you're a little bit early. I just wanted to let you know that I saw you in the waiting room. We got you connected. I'm going to kick you back in the waiting room, see if anybody shows up at 9:30. All right?
Okay, sir. All righty.
We'll see you soon.
Okay.
The other two are on their way in.
Thank you. All right, looks like Ms. Giller is connected. Counsel, your appearance for
Good morning,
the
Your Honor.
defendant.
Good morning, Your Honor. Brian Gerda, P8056, on behalf of the defendant's counter plaintiffs.
All right. So, counsel, what do we got scheduled today?
This is our motion for summary disposition, C8, C9, and C10.
Right, okay. Yeah, I looked at this last week. Ms. Giller, did you get a copy of that paperwork that was filed with the court by the counter plaintiff defendant?
Yes.
All right. Just confirming, did you submit a written request or excuse me, a written response?
Yes, I did.
Okay, that's that really big stack of documents with no explanation to it? Correct?
Yes, I'm sorry. Yes,
Okay.
that's correct.
All right, well, that puts me in a really awkward situation because I've got over an inch thick stack of documents. I'm not going to go through this stack of documents, try to figure out what I think they mean to you.
Okay.
So, you know, when you file a written response to a motion, usually you explain your argument, you explain what each one of your exhibits means, so on and so forth.
That's okay.
So I'm inclined to give you two options. Number one, you can try to do that orally today, or number two, I'll give you another date so you can submit more paperwork that explains what all these documents are supposed to mean to me.
It's very simple. I just wanted to show pictures.
Okay.
Basically, from the beginning, the first exhibit is the advertised Cordell house. When I originally looked at the house, you can see the damage. I zoomed in on where in the kitchen the damage was coming from. I had a water leak that was coming down from the kitchen. And you can clearly see it. He was talking about new appliances. I have pictures to show in there that there was not. The piping, I had an open sewage line, 2 of them that were not capped in the kitchen. I had I paid for things he was supposed to pay for. I paid for 3 trees to be removed in the back of the house.
Okay, let me interrupt you just for a minute, because I think what you're doing is telling me about all the support you have for your case against the defendants.
Yeah.
Okay, that's not what we're discussing today. What's scheduled for today is the motion that's been filed on behalf of Punjab Investments and Mr. Singh for summary disposition, which basically says your case against them should be dismissed. Did you understand? Did you read the motion?
Yeah, so I thought that's what I was doing. I submitted the pictures, the city documentation showing his default.
Well, all right, let's start with, I think, what I think will be the low-hanging fruit. One of the things, and counsel, if I misspeak about your position, would you please correct me?
Yes, sir.
One of the low-hanging fruit out of that motion, I think, is that Mr. Singh individually should not be part of this lawsuit because you did not do business with Mr. Singh. Counsel, is that a fair summary?
Yes, Your Honor.
Okay, so let's talk about that first, Ms. Giller. Why should Mr. Singh be sued individually if you did business only with Punjab Investments?
I put both names because he was the primary person that I was going through. So I put both names. I put Punjab Investments as well as Guri.
Okay, but would you agree with me that if you go to buy a GM car from a dealership and the car is faulty and you sue GM, you don't sue a GM shareholder just because they happen to own some stock?
Right. Well, I did add his company name onto Punjab Investments is listed on the documents.
No, and I understand that you did business with Punjab Investments, which is a separate legal entity from Mr. Singh. Would you agree with me there?
Well, he's the owner of it, right?
Well, he may be, but that doesn't make him the same as the company.
Okay, so they're two separate.
They're two separate legal entities.
Okay, so by me putting both names on the case, though, it still holds him liable for his company, right?
That's what we're trying to determine today. Why should he be liable if you did business with his company and he was just a representative of the company?
I want to be able to hold him accountable. I mean,
But you have to give me a legal reason why he is accountable. If you sue Kroger because you went to buy groceries and you fell and hurt yourself and you dealt with a cashier, would you sue the cashier because she worked for Kroger?
No.
Okay, that's the same situation here from a legal standpoint, unless you've got some reason why Mr. Singh is individually liable when, from what I've seen, all he did was represent Punjab Investments in the company's dealings with you. Follow me?
Yeah, I do.
I'm not saying that the company might not be liable to you.
Right.
But at this point, I want to talk about the attorney's argument that Mr. Singh individually is not liable.
Okay, he was the individual that I was personally dealing with. I put both because I want him to be able to be held accountable. If it's
okay, ma'am, what you want is not real important to the discussion today. Is there a legal reason that he do something wrong individually that makes him individually be liable? Or did he just represent Punjab Investments when you dealt with the company?
He was representing his company.
Okay. All right. Is there any other reason you thought you should put his name on the paperwork?
I put it on because he was the main person that I was dealing with.
Okay.
I mean, the legal.
So he was your contact?
Yes.
I understand that. Okay. But that alone does not make him individually liable for any damages you suffer from Punjab Investments. Understood?
Correct.
Okay. All right. So counsel, as to Mr. Singh, the motion's granted, he's out.
Thank you, Your Honor.
All right. So counsel, go pick up from there and hit the high points of the balance of your motion.
Yes, thank you, Your Honor. I just want to highlight a couple troubling procedural deficiencies from the plaintiff's case here. No response has been received at our office to this motion for summary disposition that we filed. We are working with a small claims complaint in this case that's very vague, ambiguous, doesn't really state any cause of action. In fact, the only things listed on there are items that were caused by Ms. Giller herself while she occupied the property and didn't report any deficiencies in the condition to the landlord, Punjab Investments. All that said, we just don't have much in the way of pleadings to respond to, but I hope our motion brings everything to light into what's really going on here. This is a case brought with vexatious intent, vindictive intent, because my client issued a notice to quit and proceeded with summary proceeding action to evict Ms. Giller. And on our Exhibit 3, we attached a demand for possession. And the explanation there was failing to report a leak in a timely fashion, causing extensive damage to kitchen, mold, destruction of property. And this is a common theme here. Ms. Giller resided at the property, she leased it, and would not report or make maintenance requests for things that need to be done, such as this leak that occurred in a timely fashion.
Sorry to interrupt, but how long was she in residence?
She, let's see, began on September 7, 2018. We've gone through August 2019. I don't have any extensions in my file, so I imagine she was month to month after that. And then the notice to quit was sent at October 23, 2019.
So October 23 is when you sent the notice, and she moved in when?
She would have moved in on or around September 7, 2018.
All right, so roughly a year plus. Okay, go ahead.
Correct. So with her failure to report that, we've also attached, as a landlord takes back possession of their property, or a landowner, they're able to finally go in and inspect and see what the tenant did. And we attached a list in those exhibits 4 to our motion for summary disposition as to the exorbitant amount of damages my client had to incur in completely fixing all the wreckage that Ms. Giller left behind. We don't know why all this happened. Could have been mere negligence, could have just been a lack of care for another individual's property, but the reasoning is ultimately irrelevant. The fact is that all this damage was done when my client gave her the property without all this damage at the start of their lease. And none of this is what we call normal wear and tear. A tenant is excused from being charged for anything that is considered normal wear and tear. And all this is absolutely excessive and abnormal, uncommon sort of damage that a property owner finds in their property. The bill there is $15,225 to repair what had to be done. Additionally, in addition, she did not pay 2 months of rent, and that's sitting out on her ledger, so we're also seeking that amount. So any of the claims, it's two ways, we got counterclaims here. So any of the claims brought by the plaintiff, she's not able to justify or point to any legal cause of action. As I mentioned, she's simply citing to things that she did at the property. You can't tear down a wall, wait a year, and then blame the landlord for you not having a wall. If it's something that happens in the ordinary course of living somewhere, you need to report it. You need to make a maintenance request. If there is something such as a leak, you need to report it to a landlord. Failure to do so that causes damage to the property is the fault of the tenant. And just like the other damages that we have here. So in summation, she hasn't stated a legally cognizable claim. And there's no evidence provided either in response to her motion or attached to a complaint or an amended complaint for us to work with here to even see what, if anything, supports her allegations. On the flip side, we have documentary support in support of our claims for damages in response, and Ms. Giller has not provided anything to refute that. So I am requesting that this time, and this motion has been scheduled for months now, that the court dismiss her complaint in its entirety as to the remaining defendants, the LLC, and award judgment in favor of Punjab to recover from the damages it sustained of Ms. Giller's tenancy.
All right. The last time I saw parties on this matter was back in May of, man, my date stamp was bad. It looks like May of last year. And we discussed the fact that the parties were going to go to Wayne County Neighborhood Dispute Resolution. Did that happen?
No.
Why not?
I never heard anything. I waited to hear something back from them.
I believe there's a lot more to that story.
Well, I'm giving you a chance to tell me.
Yep, I didn't want to interrupt her. So Mr. Horka from our office, and I believe there was one appearance in between May, because I was here back in May, where it was said that she hadn't received a copy of our motion for summary disposition.
Yeah, you know what?
At that hearing, I remember.
It looks like we were briefly on the record November 24th,
right,
and just talked about renoticing the motion. So what happened with the mediation idea?
I remember speaking with Mr. Horka to get a status update from that date. And he said that the tribunal, I don't remember the exact name, had never heard back from Ms. Giller, had left her multiple messages and maybe even sent an email, if my memory serves me correctly, that she was simply not responding at all to coordinate mediation. And I thought that was addressed at the November hearing where it was the decision of the court. Okay, fine, we will schedule this motion.
And that might have been my notes might just be deficient on that. Does that sound right, Ms. Giller? Does that sound right that we talked about mediation in November and just decided to go forward with the motion?
Yeah. I never heard back from the mediation people. I'm not exactly sure what happened or what he's even talking about because I was never contacted.
All right. So are you willing to go to mediation?
I want to completely be done with this case. I have a lot of stuff all the way down to city documentation. That house was never even registered for somebody to be living in it for the first year that I was there.
Okay, but ma'am, that doesn't answer my question. So we're not going to be done with this case today. So my question is, are you willing to go sit down with a mediator to see if a mediator can help you and Mr. Singh on behalf of Punjab Investments work something out between you to settle this case?
Sure.
All right, so here's what I'm going to do. Counsel, I'm going to order her to amend her complaint within 3 weeks. I don't think there was ever a motion for a more definitive statement. So I'm going to order her to give a amended complaint, file it with the court, that hopefully gives you folks a cause of action so you know exactly what you're defending. If it's still deficient at that point and that item or that issue still fits into your motion for summary disposition, then we'll deal with that at a scheduled notice for the motion. In the meantime, I'll leave it to the parties to contact Wayne County Neighborhood Dispute Resolution and get something set up.
I've just never had to do that before. So this is basically like just the a mediator that's going to sit between the two of us.
It's a mediator because, ma'am, you don't have an attorney involved, and I can't represent you because I'm the judge.
Yeah.
You need to get some advice about the case that you're involved in from somebody that's an objective observer that can talk to you and give you the skinny.
Okay.
Because if I go forward today and make a decision, I'm going to throw your stuff out because you don't know what you're doing. Bottom line.
Okay. Okay.
You haven't done the paperwork properly. And the fact that you don't have an attorney doesn't mean that the counter plaintiff and defendant doesn't get to exercise his rights under the court rules and statutes.
Right. Okay.
So, either I got to start taking over your case, which I can't do,
Yeah.
or you're going to lose because you don't have a clue what you're doing.
Okay.
Now, I don't know if your case has merit or not. I just know that the paperwork that's been submitted to the court doesn't show much for me to work with if I want to find in your favor.
Okay.
Am I making sense?
Yeah.
So if I send you to a mediator, the mediator is going to talk to both sides about their strengths and weaknesses and try to help you to resolve the matter. If you can't resolve it, that's fine. Then you're back to court for me to make a decision. But if I had to make a decision today, you're in trouble.
Okay.
So A, I think the mediator might assist in that, and B, that'll give you some time to try to get the advice of an attorney. So if we do move forward, you at least have the proper paperwork that's been filed in the proper manner.
Okay.
So are we clear on a cause of action or a course of action, counsel?
Yes, Your Honor. Can we establish some 100% accurate contact information for the defense today? Because I will set up the dispute resolution and I want it said exactly how she will be contacted.
Sure. Ms. Giller,
So
I've
I
got
think
your
I
phone
require
number.
an email.
Yeah, let's start with a phone number. I got you down with 313-932-7286.
Yes.
All right. How about an email? Do you use an email?
Yeah, it's Dawn, DAWN, the letter N, Giller, GILLER, at yahoo.com.
So it's Dawn with an extra N, Giller.
Yes. Yes.
Counsel, did you get that?
I did, but I did not get the phone number.
313-932-7286. So counsel, what I noted in my file that Singh removed from the suit as a result of your motion. The balance of the motion is going to be adjourned to a later date yet to be determined. In the meantime, Ms. Giller's got 3 weeks to file an amended complaint, and the parties are going to set up mediation.
What kind of timeline would you like for us, Your Honor, to get that mediation done?
I
think with the Dispute Resolution Center.
Yeah, I have no idea how they're scheduling right now.
Last time it took me a good 90 days from the date of scheduling because they kept having to kick it back. So
let's do this
nothing
then.
shorter.
I'll set this up for an in-house review, 90 days, so it just doesn't fall through the cracks, with the idea that hopefully we'll hear from you or Ms. Giller between now and then.
All right, and Ms. Giller will receive an email that from no reply at courtinnovations.com, and it'll be subject a message from the Wayne County Dispute Resolution Center. She will be required to go in there and accept the mediation after I create the case in there. And then we will wait, no one knows how much time, and they will assign a mediator who will reach out via email to the parties to pick a date that's mutually agreeable. So that email, check spam folders, whatever, that's where it's coming from.
Okay.
All right, we got that, Ms. Giller?
Yes.
All right, good luck. Counsel, thank you.
Thank you.
All right, thank you, Your Honor. Have a good day.
You as well. Paula, do we have an attorney on Midland Credit for Midland versus Parton?
I believe that is Mr. Nager. I was just going to say, I'm going to bring him in and verify that.
Go ahead.
And then next, if you don't mind, I'll bring in Michael Beach. I believe he is an attorney as well. Good morning, Mr. Nager. Are you here for Reese Parton?
Yes.
Midland? Okay, let me bring her in.
Got her, Paula. All right, counsel, your appearance for Midland Credit versus Parton.
Good morning. Omar Nager, P 58066 on behalf of the plaintiff.
All right, Ms. Parton, you can hear me?
Yes.
Thank you. All right, today's the date and time set for a pretrial, I believe.
I believe that's correct.
Ms. Parton, a pretrial gives me an opportunity to get some information from you folks, so I know a little bit more about what's going on with the file, with the plan of putting it on our calendar and move it towards a resolution. So, Mr. Nager, where are we at from Midland standpoint? We need some discovery. We're ready for a motion. Where are we at?
I think we asked for some discovery time if we can't resolve it right now. I don't know. I saw her answer. It says, I guess she doesn't know who we are or something. We're just a debt buying company. We bought the debt.
All right, so probably makes sense just to adjourn the pretrial until after at least 60 days with written discovery.
Yeah, I think so.
All right. Ms. Parton, discovery just means an exchange of information. So Mr. Nager is probably going to send you a list of questions he wants you to answer. He might say, if you've got a copy of such and such document, we want to see it. You can do the same thing. If there's any information you need from Midland to help you prepare your claim or your defense of their claim, then you can request those things from Mr. Nager. You understand that?
Yes.
All right. We'll send out another computer generated notice for a pretrial that'll be at least 2 months from now to give you two a chance to exchange that information. Do you have any questions?
No.
Mr. Nager, anything else?
No, Your Honor.
All right, Ms. Parton, while I've got you on, why don't you give me your phone number so I can put it in the court file?
734
Yes, ma'am.
772
Yes, ma'am.
4519.
Thank you. All right, you two have a nice day.
Can I just ask Ms. Parton if it's all right if I call her later just to see if we can discuss the case?
Yes.
Awesome.
You might get a call if you block call, but I'll leave a message if you have a voicemail and you can come, I'll leave you my number too.
Okay.
All right, sounds good.
Good luck.
Thank you.
Judge, I do have Mr. Katz in for Ursula Porter. Do you want them in next?
I don't know why he keeps doing that. Sure.
Okay.
All right, good morning again, Ms. Porter.
Good morning.
All right, Mr. Katz, are you representing someone on this file?
Your Honor, as I think we discussed last time that I'm not, but yet I'm still listed on the case and I got notice to appear on this case. Because I don't think she ever modified who the plaintiff is, and I have no idea who two individuals are that she's listed on the complaint.
Well, today what we've got up is a request for default judgment against Barrington Apartments LLC.
Correct. No such entity exists, Your Honor.
Okay. All right. So, Ms. Porter, you understand what's up today?
Yes, I put down Stacy Gilmore and Gordon Lambert too.
Okay, but that's not the judgment that's been entered or you're seeking to enter.
Okay.
Did you, I don't know where this judgment came from. I'm assuming you prepared it?
Yes.
Okay, but the only name on it under defendant is Barrington Apartments LLC. You understand that?
Yes, sir.
All right, and the reason we scheduled the hearing is because on that judgment, you're asking for attorney fees of $1,925. And I don't know how you're asking for attorney fees because you've never had an attorney on this file.
And she sent me the paperwork and I changed it up. You sent me, told me to send in the original people names, Stacy Gilmore and Gordon Lambert. That was on the first one. Cause they said, I remember he said they have no identity of the Barrington's apartment. And so I entered Stacy Gilmore and Gordon Lambert. And they didn't appear in court.
I don't have a judgment with their name on it that's been submitted for signature. The only judgment that's been submitted to the court is the one for Barrington Apartments LLC that requests attorney fees. So if you want a judgment with individual names on it, you've got to submit that judgment and then we can deal with that one.
Okay, that's what I'll do.
But the only one I've got in front of me, and the reason I set it for a hearing was because it's asking for attorney fees, and I know you never had an attorney represent you on this file.
I'm my own attorney.
Right.
Yes, sir.
Right.
Yes.
And as such, you can't ask for attorney fees because there's no attorney. You follow
Okay.
me?
Yes, I
Okay.
do, sir.
All right, so I think we're in agreement that nothing's gonna happen on this piece of paper. You're gonna file another judgment.
Yes, sir.
Okay, and Mr. Katz, do you want us to remove you from the register of action on this file so you no longer get notices?
As it relates to the parties listed, yeah, I think I could be taken off of it, Your Honor.
Yeah, the only parties listed, I'm looking at my ROA, is plaintiff, obviously, and 3 defendants, a Barrington Apartment LLC, Stacy Gilmore, and Lambert Barrington Apartment. Those are the 3 defendants we've got listed.
And I don't know who any of those are yet. Miss Porter needs
Stacy,
personal
Stacy
service.
Gilmore
Hold on, Miss
works in
Porter.
your office.
Hold on, Miss Porter. Go
She
ahead, Miss
needs
Katz.
personal service on those, on any of those individuals as well, which I don't think has been established since I don't even know who those people are.
Okay, well, I don't know why you would know about anything on those if you haven't filed an appearance and gotten any documents on them.
Correct, but I do get copies on them, Your Honor.
Okay.
And I
Alright.
think we've already established that in previous, that there was never any personal service on any of these individuals since.
Yes, it was. Yes, it was. I delivered it to Stacy Gilmore. She's the manager at your office, and I gave her a certified letter to her face for her to appear in court. I delivered it myself.
So my question, Mr. Katz, is we keep getting you involved, but it sounds like you're not involved. You shouldn't be. So,
Under the scenario right now, I don't think I need to be involved.
so I'm going to make a note for the clerks to remove you from the notice stream.
Okay. All right.
And I'm also making a note for Ms. Porter. I'm making a note in the file that the default that's been submitted against Barrington Apartments LLC, you don't want to move forward on that one. You're going to submit another one.
Yes.
Agreed?
Yes.
Okay.
Okay.
Thank
All
you.
right, have a good day.
Thank you.
Thank you, Judge Oakley. Have a
You're
blessed
welcome,
day.
ma'am. You as well.
I'm going to find out who Michael Beach is.
Yeah, go ahead.
Good morning, Mr. Beach. Can you tell me what case or cases that you are here on?
Yeah, I've got CACH versus WA, KWAW.
That was scheduled at 9 o'clock and the other party has not checked in yet, Judge, that I'm aware of. I don't see anybody over in the waiting room.
All right, I'm sorry, Paul, I was writing notes. When was that one scheduled?
It's scheduled at 9 o'clock, Cash LLC versus Quad, KWAW. I don't see anybody that's checked in with that name. We have one that's unidentified and that's it.
Let's check on the unidentified before I do something.
Okay, hang on just a minute, Mr. Beach.
Counsel, it looks like the last time we were on this file was January and there was going to be an amended police report by the defendant?
That's correct, Your Honor.
Okay. Do you ever, you know if that happened? Did you get a copy of it or anything?
We didn't get one to the court. Did you submit anything to the court?
No.
Your Honor, to be totally honest, I was just looking at the notice this morning, and if you look at the notice, the address it was sent to for the defendant, it's not the address that he put on his objection.
Looks like it went to the Schrock address.
Yeah, and on his objection, he had it at a West. So I don't know. Did the court at the last hearing, did they give us a new date? I don't know.
Yeah, on January 19th, we set this date.
Okay, so he had at least had oral notice of it.
Yeah.
Judge,
Sandy, are you listening?
Yes, Judge. Yes.
Counsel, I think we better reschedule this.
Yeah, I tend to agree with you, Judge. It's just to be I'm all for fairness, but you know.
Yeah, I mean, I'd like to not see it drag on, but given the fact that he sent something in with address A and we're still using address B.
Yeah, I totally get it. But I just wish he would have followed through on what he was supposed to do.
Yeah.
Judge, Galaxy Note 9 is not responding to my chats.
Okay.
Doesn't even look like they're trying to connect. I'm going to go ahead and remove them and make them call back in. So,
Yep.
okay. Okay. Are you finished with Mr. Beach or?
Yeah, Mr. Beach, we'll just send out new notices after the clerk's update his address.
Okay, thank you, Your Honor.
Thank you.
Okay, I do have Mr. K9 in, and his first one is, it's Synchrony Bank versus Diana Brenner at 9:15.
And you got Miss Brenner?
Yes. And he has a few of them, so. She's on her way in.
All right, counsel, good morning. Your appearance for Synchrony Bank versus Brenner?
Yes,
Good morning. Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828 on behalf of the plaintiff.
Good morning, Miss Brenner.
good morning.
Today is a date and time set for a pre-trial, Miss Brenner. That gives me an opportunity to get some information from you two about this file. So hopefully we can put it on the calendar and move it towards a resolution. Understood?
Yes,
And counsel, where are we at from Synchrony's standpoint?
We've actually resolved the matter. Someone from my office spoke with Ms. Brenner's POA, debt management company. We just need to get her a proposed consent judgment with the terms agreed upon. So perhaps an adjournment, brief adjournment of today's hearing, please.
Why don't I do this? Why don't I set it for an in-house review 30 days out?
That would be great.
If in 30 days we don't get a piece of paper from you two that settles the case, then we'll renotice the pretrial.
Perfect. Thank you.
Ms. Brenner, does that make sense? Any questions?
yes, I thought that I signed an agreement, already. They had, sent me like a letter and I okayed it. And they come to conclusion of the settlement, with a payment plan. So I went online here and, I'm just waiting for, I guess the letter to go to you guys to say that it's been, settled.
Ma'am, you should inquire with your debt management company because I emailed them personally a proposed consent judgment Friday night and I haven't heard anything back from them. So,
Oh,
but it's resolved. So we'll just get
okay,
paperwork in. Thank you.
okay, thank you,
Good luck, Ms. Brenner.
thank you.
Thank you, Your Honor. Thank you, Ms. Brenner.
Counsel, your next one's not scheduled at this time slot. Is that correct?
It's 10 o'clock and I'm going to log into Grand Blanc and another attorney's going to log in for me.
That's fine. We'll kick you out then.
Have a good day.
Yep.
Okay, I have no idea how to say it. Nodar.
Notaburino. Yep.
Yeah.
On what?
And
That's
for
University?
Yeah, Winnie Cooper is the defendant on University of
Bring him in.
Detroit.
All right, looks like everybody's connected. Counsel, your appearance for University of Detroit Mercy versus Cooper.
Good morning, Your Honor. Jessica Notarbarardino, P83454 on behalf of the plaintiff.
Good morning, ladies.
Good morning.
Ms. Cooper, today's the date and time set for a pretrial. A pretrial is an opportunity for me to get information from you two about the file. Hopefully we can set the file on our calendar and move it towards a resolution. Counsel, where are we at from plaintiff standpoint?
I know that Ms. Cooper filed bankruptcy, so we had some issues as to the exact balance, which I'm working with the client to figure out, but we also have a settlement on the table right now, so I'm just waiting for a response back from the client. So if we could just get maybe 30 days of discovery, we should have the case resolved, whether through settlement or we have a definite amount of what she owes due to the bankruptcy.
All right, so I'll make a note, 30 days written discovery and reschedule pretrial.
Yes, that'd be perfect.
All right. Ms. Cooper, discovery is just an exchange of information. So council's probably going to send you a list of questions and ask you to answer them. Maybe she'll ask you for a document or a copy of a document that you might have that they don't have. And you can do the same thing. It's a two-way street. So in essence, we're going to give you 30 days to work this out amongst yourselves. If that doesn't happen, then we'll reschedule the pretrial. We'll have another conversation with the three of us. Understood?
Understood.
Any questions, ma'am?
No.
Good luck to you then.
Thanks.
And will the court just mail us a notice with the new date?
Correct.
Okay, perfect. Thank you.
You're welcome.
Judge, I don't see Dumas in yet, and it was scheduled for 9:15. Do you want me to bring Mr. Groen in so we can let him go, or you got to wait for a while?
No, we'll bring him in. Go ahead.
Okay.
Counsel, your appearance on Midland Credit versus Dumas.
Good morning once again, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of Midland Credit Management.
And this matter was set at 9:15, which means Mr. Dumas or Miss Dumas was supposed to be in the waiting room by 9 o'clock. And it's now, according to my phone, 9:50. So if you'd like to submit a default judgment under the 7-day rule, we will entertain that.
I appreciate, Your Honor. We will do so.
All right. You got anything else this morning?
I think that's my last one, Your Honor.
All right. Thank you. Stay healthy.
Thank you. You as well.
Thanks.
Judge, I'm going to have to bring in some of these attorneys. They don't let me know who they're on here.
Yeah.
Okay.
We're looking for somebody on Jefferson Capital from Mr. Mannion's office.
Yep, Kara Bailey, Your Honor.
Well, how's that for timing?
You have for Mary Jane Elliott. Are you for Mr.?
I'm an attorney in the office. Our office is Mary Jane Elliott, PC. Daniel Mannion's my managing partner. So yes, his name usually appears on our pleadings.
Thank you.
Yep.
All right. And Paul, I don't see Miss Helton anywhere. Do you?
Yeah, Christian Helton. Well, they were in there.
Was she?
Yeah, right here. I got her.
Top. Yeah, bring her in.
I also had a 9:30, Your Honor.
We're moving in that direction.
All right.
Hello.
Good morning, Mr. Helton. Counsel, your appearance for Jefferson Capital.
Kara Bailey, P73071 on behalf of the plaintiff today.
All right. Today's the date and time set for pretrial, correct?
Yes, Your Honor.
Mr. Helton, a pretrial gives me an opportunity to get some information about the file from the parties so we can put it on a calendar and move it towards a resolution. Counsel, where are we at from Jefferson's standpoint? Discovery, motions, trial, settlement, where are we at?
Well, actually, Your Honor, we mailed Mr. Halton a dismissal back at the beginning of February. We did a little bit of research and agree with what he's saying about being a minor at the time.
All right, so case is dismissed by plaintiff,
No, okay.
right?
Yes, Your Honor. Just to put it on the record, the dismissal actually put a little bit of release language in it. The dismissal we sent Mr. Halton said the parties release each other, including anyone working on their behalf, from all claims and actions related to the account, whether known or unknown, prior to the date of entry of this order.
Did you get that, Mr. Halton?
I don't know. I had a lot going on last month, and I don't think I got it. I mean, I could have.
Counsel, can you email that out if Mr. Helton's got an email address?
Sure. What's the email address?
cj.helton@yahoo.com.
Okay, CJ Helton.
Yeah, it's a dot in between CJ and Helton.
CJ.Helton
Yahoo.
at yahoo.com. All right. All right, I'll get that out to you. Your Honor, I don't know what you want to do as far as this.
We'll just set it for an in-house review so we don't lose track of you. Mr. Helton, here's the way that's going to happen.
Okay.
She's going to send you the document. If you agree with that, just send back a reply that says, yeah, that works for me. She'll sign your name with your permission. She'll sign it. She'll send it to the court. Then we don't have to do a lot of back and forth through the mail.
Okay.
Okay?
Yeah.
Council's at work?
That is perfectly fine, Your Honor.
All right, you two have a nice day.
No, you too.
Miss Bailey, you have another one
I do. I have
for
Ms.
Diana
Diana
Jones.
versus
I believe
Diana
this
Jones.
is her. I'm going to bring her in right now, Judge.
Okay.
Diana Jones is scheduled at 9:30, Midland versus Diana.
Yep.
And she's not connected.
And Miss Jones is represented.
And I do have that attorney. Hang on.
Yep,
I didn't look that far. I'm sorry
I
about
got
that.
him. Bring him in. All right, counselors, appearances for Midland Credit versus Jones.
Sarah Bailey, P73071 on behalf of the plaintiff today.
Alexander J. Barry, Santor on behalf of Diana Jones. Hello, Kara. Hello, Your Honor.
Good morning. Counsel, we can't get Miss Jones connected. It looks like she's just caught in that endless loop.
Is she in the waiting room?
She's actually in the meeting, but she's not connected with audio, and she's not on screen. She looks like she walked away from her camera.
Oh, geez.
So her audio is not connecting, and she's not on the camera. And I don't have a phone number for her. So let's see what we attorney types can figure out. Where are we at on this?
I don't think us attorney types figure out much.
Speak for yourself.
Your Honor, Mr. Berry and I have not spoken regarding this case yet. I'm going to make the assumption that we probably need a little bit of discovery and that he'll contact me if we can reach a resolution.
Absolutely.
So why don't I just set it up for written discovery only, 60 days out, reschedule the pretrial. If you resolve it before then, or you decide you need a motion before then, no sense having a pretrial just to tell me that.
Yes, Your Honor.
We're easy to find. You can contact us. And Mr. Santero, I'll leave it to you to contact your client and let her know what happened today.
Absolutely, Your Honor.
All right. Anything else?
No, Your Honor.
All right. You two have a great day.
You too, Your Honor. Thank you.
Did we let Mr. Canine go or Canine go?
He let himself go because
Oh,
he's gonna
that's
have
right. He's
another
somebody
attorney
else.
come in and catch the next file.
We do have that person.
Which person is that?
Daniel Trevor is the attorney for
For what?
Michelle Davenport. It's synchron.
Oh, on Synchrony Bank versus Davenport?
Yes, sir.
And Davenport is represented by Attorney Daniel.
And we do have Trevor Daniel in the
Yep.
waiting room.
I brought him in. You can bring plaintiff's attorney in.
Do you know who was signing in for him?
No, I thought you said you had that person.
No, Mr. Canine, or Canine, sorry. I had the person for the, Mr. Trevor Daniel is who I was talking about.
All right. Well, we'll have to figure it out. Let's just bring them in one at a time, figure out who's who.
Okay, Mr. Daniel. We had Mr. Canine on. He had another court that he was going to be at. So we're going to see who's signing in for him.
Okay.
Mr. Miller, what are you here for?
Good morning. It's Ready Day Construction versus Benjamin Miller. My attorney David Sebastian should be waiting as well.
Paul, I don't have a file for that one. Do you have it on the docket?
It's at 9:45. Carpenter versus Miller.
Call somebody and tell them to bring me a file.
Will do.
All right, Mr. Miller, back in the waiting room till we're ready for you.
Okay, thank you.
You're welcome.
Sandy's on her way down with it, Judge.
Thank you.
I'm going to try one more time for the Galaxy.
Go ahead. Christina, what are you calling in for?
Hello.
Christina Kemp?
No, I'm Annette Dumas.
All right, you're late, Miss Dumas. What happened?
No, I've been here. I've been here since maybe 8 after.
Yeah,
And
but
I've
you didn't log in with a name, and when we tried to get you in before to talk to you, it
Oh.
wasn't connected.
Oh, I didn't know I had to do a name. I just logged in with your ID number.
Yeah, and
That's
then you
all
come
it
in, you
said.
come in with a phone, and it's hard to connect a phone to an individual file. And when we brought the phone in, you weren't there to talk to us. So we'll have to see if we can get the attorney. We've already sent the attorney on his way.
Other one, the bacon, egg, and cheese croissant.
So we'll put you, now that we've got you labeled, we'll put you back in the waiting room, see if we can get a hold of that attorney.
Okay, great. Thanks.
Okay.
All right, I don't know who Kempf is, and she's not talking, so she's gone. Paul, any idea who Daniel Landman is?
No, I don't. The Nick Metaxas, I have no idea either.
Bring them in. Let's find out if they're the missing attorney.
Okay. Nick Metaxas.
Yes, I'm here. Good morning, Your Honor. Nick Metaxas.
What case are you on, sir?
I'm on Bellinge. The defendant's name is Kempf and Rosales.
That's the very last one on the docket. You're here for Mr. Landau? Or are you here for Dempin?
No, Mr. Stephen Bellinge.
Well, I don't have those names on my docket.
I'm sorry. No, I don't either. I'm sorry. Do you have the case number, sir?
I do. And it's 201656. And I can give a quick update. We received a notice for the hearing for this morning, but I think they're very close to a resolution. If we can, I'm not sure if you have this set for I think it was for lack of progress. But I think if we have 30 days, we should be able to resolve it and get a consent judgment on the record, Your Honor.
That sounds great, but I don't have a file, so I can't do anything until I get the file.
Hang on just a minute. I'll call Sandy.
Miss Jones, you connected now?
Yes, I am so sorry. I have the days wrong. I'm supposed to come on the 18th, which is Thursday, sir.
On what file?
On what file? The case number?
No, the file. Who's suing you?
Nobody's suing me, sir.
All right, then see you Thursday.
Okay, I will see you Thursday.
Okay, the case number 201656, Mr. Metaxas, was
That's
set
correct.
for a lack of progress and it was taken off the docket.
It was taken off the docket.
Yes.
Okay. Do we have, we still have time on this, or do I need to, I need to request
Call
an
the
order for
civil clerk's
reinstatement?
counsel. Call the civil clerks and find out.
Okay.
I'm assuming they took it off the docket today because somebody had contacted them and got it on a calendar for something else. But that's just an assumption.
Okay. Thank you, Your Honor.
941-4463, extension 211.
4463.
Extension 211.
Got it. Thanks again.
Don't call yet. Give her a call this afternoon after things slow down.
Okay.
Thank
have
you.
a nice- have a good day.
Mr. Landman, I also have Jenny Scheid from Swistack and Levine in the waiting room.
Yes, she is our newest hire and she is monitoring, getting up to speed as quick as possible. So
So you want me to bring her in so she can listen in?
absolutely.
Okay. And Judge, Mr. Canine's office just checked in again.
iPhone, who are you?
Hi, I'm Susan Winters. I'm here for the MEA.
All right, Paul, would you rename Miss Winters and put her back in the waiting room till we're ready for her?
Got it.
All right, gentlemen, I think we're ready on Synchrony Bank versus Davenport.
Yes.
Okay. Appearances.
Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the plaintiff.
Good morning, Your Honor. Trevor Daniel, P73480, on behalf of defendant.
Thank you, fellas. Last contact I had with this file was May of 2020. Settlement likely, we set it for an in-house review. So where are we at?
We unfortunately, Your Honor, we've been unsuccessful, I believe, in part due to the balance. If it's okay with the court and opposing counsel, I was just going to request the trial date, maybe 30 or 60 days out, please.
Okay.
That's fine. I think we were close, and then COVID happened and issues with my client
Yeah.
and employment.
Have you guys tried mediation? Would it help?
Sure. I think informal mediation, in my experience, is more beneficial than case evaluation in these situations. But
I agree.
Sure.
I agree.
Yeah.
Yeah, I'm not opposed.
All right. So, Mr. Canane, you want to set it up on your own?
Sure. Does the court? I know sometimes the courts in the area use like citizens mediation in some of those entities.
We've been sending people to Wayne County neighborhood dispute resolution.
That's okay with me.
I just heard this morning that they might be 90 days out.
Oh.
So why don't I do this? I mean, we got two attorneys. It sounds like you're playing well together. Why don't I just set it for another in-house review so it doesn't fall through the cracks, with the idea that you guys are going to get something going with a mediation and let us know what's going on.
That's fine.
That would be great.
If you need a trial date, we'll give you a trial date.
Okay. Thank you.
All right.
Mr.
So
Daniel,
I'm going to make a note. Party going to sell. I'll just make a note. Parties to explore mediation, and we'll do an in-house review for 60 days out.
That's fantastic. Thank you.
Okay.
All right. Thanks, guys.
All right.
Okay.
Thank you.
Thank you, Your Honor. Take care. Thank you, Mr. Daniel.
Yep. Thank you.
And I also have another file I need, because I sent the plaintiff out and the defendant finally got in.
That's not 18. Oh, you mean?
I don't
one
work
that
with
you sent back
numbers.
with me?
Yeah.
Okay. The one that I couldn't, that you said you didn't have, I don't know what I did with it. I have the whole docket, but here's the ROA. We can just reschedule it and I can find it. It's just set for lack of
That's the
progress.
ROA for the file I just gave you.
That's one I thought you said you didn't have.
No, the one, the attorney Matakis or whatever, I didn't write down the
Okay,
file.
when he
Yeah, Paula
came-
might have
okay,
made a note on it.
Okay, all right.
But I need the file on Midland versus Demas.
Demas,
It
okay.
was scheduled at 9:15.
Yeah, okay.
I'm going to find out. I'm sorry.
I'm gonna see if Donna is the Donna Brown we need for,
That's what I was just going to do.
Yeah. If we get her connected.
Let me see if I can send her a chat sometimes. She's not looking up. There she goes. There she goes. We caught her. There. You're muted, Judge.
Donna, what is your full name, ma'am?
Donna Michelle Brown.
That's it. You're the one we're looking for. Let's bring the attorney in on the other side. All right, Miss Winters, we've got Miss Brown. If you'd be so kind as to put your appearance on for the Michigan Education Association.
Yes, Your Honor. My name is Susan Winters. I'm appearing on behalf of the Michigan Education Association.
All right, counsel, the last note I've got is from December 15th. We opened the file up for written discovery. with the idea that plaintiff would schedule a motion for summary disposition. I don't see that has been done, so where are we at?
Well, I believe that the motion for summary disposition was filed. I thought that that's what was scheduled for hearing today, Your Honor.
We've never received anything.
Let's see here.
Scheduled today for a hearing for lack of progress. Sounds like maybe somebody dropped the ball.
Well, I know that Keith Cox from my office filed a motion for summary disposition and
Not with this court.
mailed it. Well, I apologize, Your Honor. I'm trying to review here that he got a hearing date from your court for April 20th.
Sandy? Sandy, counsel just told me that they've got a hearing date for a motion. I've got it on the no progress docket.
They've got a hearing date for a motion?
Yep. In April.
Okay, so then- Okay, so Emily didn't take it off. It was just, they called for it and we just put it on the 10th.
Okay,
That
the
was-
sloppiness
Yes.
makes me look bad. I don't like to look bad unless
makes
it's me.
Look bad, I know, and I.
Ms. Brown, did you get a copy of that notice?
It says hearing for lack of progress.
Did you get one for the April date? Which is that? April date.
April 20th at 10:15.
No, not yet. This says notice to appear today, Tuesday, April 6th.
Okay. Did you receive a copy of the motion from MEA?
No, not yet.
All right, let's confirm your address so Ms. Winters can make sure she got the right address. We've got you down on Sussex and Romulus,
Yes.
35897.
Right.
All right, counsel, can you make sure she gets a copy of that motion?
Yes, I could, Your Honor, and I will. I still don't have a copy of Ms. Brown's answer. Could she send a copy of that to me? I don't know what her dispute is.
Ms. Brown, could you do that?
The one that was sent to court?
Yes.
The answer you filed with the court, correct?
Okay, forward that email.
All right, so Ms. Brown, you're going to get a copy of the motion that's been filed by the plaintiff. You can respond to that in writing. I would encourage you to do so. And then on that April 15th date, we're going to have a discussion. I'll let both sides add anything orally that they want to add to their written paperwork. Understood?
April 15th?
Yes,
No,
ma'am.
it's April 20th. Excuse
April
me, Your Honor.
20th?
It's April 20th, yeah.
At 10:15, I'm sorry, April 20th.
Okay.
All right?
And that'll be something like this again?
I can't see that. No, well, the notice might be, but the motion's going to be more involved than that.
Oh, okay.
Understood?
Motion. Okay. Now, I did get a big packet yesterday like this.
Well,
That's it.
Okay,
This is it?
That's the motion, yes.
that's the motion.
Okay. So this has a date on it?
Yes, if you look at the second page, like you lift the page up, it says notice of hearing.
Okay.
No
Okay,
problem.
so this just came last night. Okay.
Ms. Winters, does your notice have our Zoom ID on it?
I believe it does, and I do apologize. I'm at home and my dog is barking. I do apologize.
All right, well, Ms. Brown, the same way you got into today's meeting is the way you're going to get into the meeting on the April 20 date.
Okay, it does, sir.
Okay, all right.
Ma'am, it does.
Thank you. Anything else, ladies?
That's it, Your Honor. Thank you.
Stay healthy.
You too. Take care.
Thank
Good
you.
to see you.
Go pet the
Okay.
dog.
I will. Sorry, I do apologize.
All right.
Okay, thank you.
It's the world we're in.
That's right. Bye-bye.
Mr. Landman, I'm
Yes.
going to check these last two people in our waiting room. It doesn't look like either one of your defendants have checked in, but I'm going to check these out.
Sounds
And
good.
hang on just a minute. Okay. I wrote it down, I think.
Hi. Hello.
Annette,
Yes.
what is your last name?
Dumas.
All right. Paula, we're trying to get hold of the attorney on that file.
Okay. Did
Can you
you?
relabel her?
Yeah. Did you duck out and then come back in, Ms. Dumas?
No, my phone disconnected. I have been.
Okay, all right.
since
I got you
after-
relabeled. We know who you are now.
Yeah.
Thank you. Hang on.
You're Uh-huh.
I'm going to put you back in the waiting room.
Mr. Sebastian, you're calling in on Carpenter versus Miller.
Yes, sir.
Have you heard from plaintiff's counsel?
No, I have not.
And what's scheduled today?
The defendant's motion to set aside the default judgment.
All right, give me just a minute. I'm going to call that office, see if they're going to join us.
Okay.
All right, Mr. Sebastian, I just tried to call Mr. Rucker and got a recording that said his voice mailbox was full. This was scheduled at 9:45. It's 10:15. You win. Submit an order.
Okay, thank you very much.
You're welcome.
Judge, Mr. Groen is going to check back in for Ms. Dumas. And do we want to bring Mr. Miller in so his attorney can tell him what just happened?
Sure. Who's his attorney?
Sebastian.
Mr. Sebastian.
Oh, thank you.
Mr. Miller, are your attorney, what happened to Mr. Sebastian? Mr. Sebastian was just in here. You may want to contact him to find out what just happened, okay?
Okay.
All right, thank you, sir. I'm going to try Mr. Elias. I have no idea who he is. Good morning, Mr. Elias. Can you let me know what case or cases you are here on, please?
Parker versus Petra 77 LLC.
That's the one with Dennis Buds. Bring him in. Gentlemen, appearances for Parker versus Petra.
Dennis Buds on behalf of Parker.
Good morning, Mr. Buds. Long time no see.
Likewise.
Kevin Elias on behalf of Petra
Defendants.
77.
All right. And gentlemen, I'm covering this file for Judge Green, who's trying to make her way back from Colorado.
Uh-oh.
We set this up for a no progress docket. So what's going on?
I have
So I'm
submitted.
understanding the case settled.
I have submitted a skipping order for dismissal to counsel for the defendant.
I submitted and I gave it back to you.
I never
I
got it
sent it
back.
back to you. I sent it by email. I could send it again, but I think this is more ships passing in the night.
That's probably what it is. Are you the good
Yeah.
ship lollipop?
Sorry to waste the court's time.
All right.
What's
no
that?
problem. All right,
Who
so
the
I'm just
court
gonna make a
wanted,
note, I'm gonna make a note, case settled, dismissal to be submitted. We'll set it for an in-house review.
That's
Great.
cool.
Thank you.
All right, have a good day,
Dennis, I'll
guys.
send it again to you.
Okay, thanks, Kevin.
Yep, bye-bye.
Hey, Kevin, are you in the office?
Yes.
Okay, I'll call you on the other thing.
All right, thanks.
All right.
All right, stay
Bye-bye.
healthy, guys.
Yep.
I've got Mr. Groen back in the waiting room, Judge. You want me to bring in him
Please.
and Miss Dumas?
Please.
Citizen. It's 39, yeah.
Miss Dumas, we do
Okay,
have you
thank you.
back in the
Hi.
waiting room. Thank you for calling back in, Mr. Groen.
You're very welcome.
Mr. Groen, your appearance on Midland Credit.
Good morning here again, Your Honor. Brian Gruen, Groen. P number is 56673 on behalf of Plaintiff Midland Credit Management.
Thank you. All right, Mr. Dumas, we've got a pretrial scheduled for today on the file. Pretrial is an opportunity for me to get information from the parties so we can hopefully put the file down on the calendar, the court calendar, and move it towards resolution. Counsel, where are we at from Midland?
Your Honor, it's just basic credit card debt. Pursuant to her answer, it sounds like she's willing maybe to make some type of installment payment arrangement. So I'd be more than happy to discuss that with her to see if it's something we can work out.
Ms. Dumas, should we put you and counsel in a breakout room so you can talk about that?
Yes,
All right, we'll do that.
thank you.
All right, Maple Leaf Gardens versus Collier. Appearance, please.
For the record, Daniel Landman, Your Honor, on behalf of the plaintiff. In addition, I'd like to introduce you to Jenny Scheid, who is the newest hire at our office. And
Hi, Jenny.
Bring her up to speed as quickly as we can, Your Honor, on what we do and how we do it.
Good.
Judge,
Morning, Your Honor.
I do have their client in the waiting room. I'll bring them in right now.
All right, and joining us, we've got Brandy Conway from Maple Leaf.
Yes.
Who we don't have is Constance Collier. So what do we got scheduled today?
Your Honor, this is a motion to permit issuance of an order of eviction beyond 56 days after entry of judgment. The judgment was entered actually in October with a pretty sizable balance. We submitted an order of eviction in the fall. For some reason, it was returned to us by the court. I'm not certain of the reason why, but that caused more than 56 days to elapse. Meanwhile, the tenant continues to occupy the premises. No money has been paid beyond the judgment date, and it was a large balance as far as a possession judgment is concerned. Because more than 56 days have elapsed, in order to obtain an order of eviction at this time, as the court is aware, we need to provide notice and an opportunity for hearing. That's the purpose of this motion. We also, I believe, provided a proposed order of eviction at the time the motion was filed, and we are hoping that the court will see fit to grant the motion and allow that order of eviction to be carried out.
I am going to grant it with a caveat. The notice that your office prepared did not include the Zoom information. So if we hear from Ms. Collier in the next few days and says, hey, I didn't get a chance to talk about this, then I'm probably going to set another hearing.
Fair enough.
Yep, just future reference. Put that in the notice and that'll make it cleaner. All right, anything else?
No, as far as this case, no. I think I've got one other one with you and also a motion that we're withdrawing.
Okay.
Stephen Crow is the other case, Judge.
Crow is the motion that we're withdrawing. We also, I thought, had one for Blount and Booth.
I don't see that one on the docket.
Nope.
23405 LT.
No, that's not on our docket. You might want to call Sandy and see what happened with that one.
Do you want me to do that real quickly, Judge?
No.
Okay.
Counsel can call, find out what happened.
Thank you.
All right. And Brandy, I think we're done with you.
All right, thank
Have a nice
you.
day.
You too.
Actually, she is the plaintiff on the other one too.
The
On
one that he
Crow.
just said they're withdrawing their motion.
Yeah,
Yeah, so I guess we don't need her.
okay.
All right, and you two attorney types will put in the waiting room till you figure out what's going on.
Sounds good, Your Honor. I'll call the clerk's office right now.
Thank you.
Judge, I still show one on the docket that it was for no progress or lack of progress.
That Bellvilla
Yeah,
just got dismissed.
thank you.
Yep. So all we're left with is the one that he's checking with Sandy on, the Crow matter. No,
And
the
I
one
have,
that's not on the docket.
yeah, and the one, well, it is on the docket. It's third from the bottom at the very end.
No,
We
no, it's not, Paula. No, it's not.
Hi, Judge. I have the one, the motion was sent back because it wasn't signed in that. And so we're, that'll be reset.
Which
once we get-
file?
For the Maple Leaf and Blount, the one that we do not have on the docket.
Right. And
That
Crow's
one-
been withdrawn.
Okay.
Right, and Crow's been withdrawn. And I do have on the phone with Emily right now. Who is it, Emily? Tyrone Rucker for 1961-62. What is he saying, Em? He said he never received notice.
Well, he can contact the other attorney and see if they can work something out then.
Okay, yeah, tell him to contact the other attorney and see if he can work something out.
And Judge, we do have Annette Dumont, Mr. Groen in the waiting or in the breakout room.
Oh, that's right. Thanks. All right, so I understand that we're going to renotice that motion for the Blunt matter.
I don't know, Your Honor. I'm on hold right now with.
Oh, I thought Sandy had communicated that with you. Yeah, the
No, I-
motion came to the court, but it was not signed, so she sent it back to your office to get it signed, and we'll reschedule.
Let me see. I thought there was a subsequent one that was submitted that was signed. There was. February 11th was the date on the motion and the notice of hearing, and it was signed. I think it was probably submitted at the same time as the
Well,
motion.
we're not hearing it today, counsel, because
Okay.
the notices haven't gone out and, okay.
All right,
So,
all right, so, all
watch for your notice.
right, so there's going to be a new notice sent out by the court, though?
Correct.
Or, okay, so we don't have to resubmit the motion?
Nope.
All right.
Nope.
Very
Thank
well,
you.
Your Honor, thank you.
All right, what are we doing with the Midland versus Demas?
Your Honor, she submitted a settlement offer that I'm going to have to take to our client. So probably the best thing we can maybe do is just set this out to your next pretrial date. I'm hoping between now and then, we can hopefully reach a settlement amount and get the documents over to Ms. Dumas.
All right, Mr. Demas, that makes sense?
Yes.
All right, we'll adjourn it out at least 3 weeks. We'll send out a notice.
Thank you.
Thank you, Your Honor.
Good luck.
Thank you. Thank you, Ms.
Mhm.
Dumas.
Thank you. Bye-bye.
Bye-bye now.
I removed her, so. And then
Yeah.